5 seconds to go. Start. Sixthly, there is nothing to show that respondent number 2 can write his name in English. Therefore, questions survives how he signed the deposit slip while depositing the check in English. Seventhly, it appears from the WV submitted by the appellant that when the respondent number 1 lodged complaint with it, the appellant on several occasions asked the respondent number 2 to meet its branch manager. However, on one pretext or the other, the respondent number 2 avoided meeting him. An honest person never fight shy of proving his bona fide. Lastly, the respondent number 2 has not placed on record any counterpart of deposit slip to show that the said amount were indeed deposited by him. All these emerging facts induce us to hold that the disputed check indeed belonged to the respondent number 1. Given that it is virtually impossible for one to know the account number of another person, and more so as passbook is stated to be updated by Group D staff of the bank, it would be myopic not to believe that the goof up created at the end of the appellant itself. Besides this, since the appellant made a great blunder while crediting the amount of the check to the account of respondent number 2, we feel the appellant must own up due responsibility in this regard. The respondent bank, being aggrieved by the said holder, had preferred the revision petition before the National Commission under section 21B of the Consumer Protection Act, hereinafter referred to as the said Act. The National Commission allowed the said revision application void the impugned order as stated herein above. It is pertinent to note that pending the revision application, the National Commission had called for a report on the whole matter from the SBI. Accordingly, a report dated 19th March 2019 was filed by the regional manager of the SBI. Relying upon the said report, the National Commission allowed the revision application filed by the bank by observing inter alia that though revisional jurisdiction of the Commission under section 21B of the Act 1986 has a defined purview and ambit, it does allow interference if grave misappreciation of evidence or superficial appraisal of a case is discernible on the part of the two fora below. This court is at a loss to understand as to how the National Commission could have sought for a report at the revisional stage, that too from an officer of the party which already had an opportunity to submit all the documents necessary for the purpose of defending itself before the consumer forum, and as to how such a report in the form of an additional evidence produced in the revisional stage could be relied upon, in respect of which the two fora below had no opportunity to deal with. It is needless to say that the revisional jurisdiction of the National Commission under section 21B of the said Act is extremely limited. it should be exercised only in case as contemplated within the parameters specified in the said provision, namely, when it appears to the National Commission that the State Commission had exercised a jurisdiction not vested in it by law or had failed to exercise jurisdiction so vested or had acted in the exercise of its jurisdiction illegally or with material irregularity. Stop.